Welcome back, everyone. It's Peter Tragos, the lawyer you know, and today we've got Big George on here for part 2 of R. Kelly's motion for judgment of acquittal. We broke down in detail part 1 and went through about half of this motion. In this video, we are going to break down part 2. We're going to do it a little more in summary. We'll go through the parts. There's a lot of repetition talking about each of the racketeering acts. We're going to break it down, go through it, see what we agree with, disagree with. And also at the end of the video, we're going to discuss other cases that have been where RICO has been interestingly applied in criminal cases and even some other civil RICO cases. So we'll save that for the end of the video, but make sure you like the video if you're interested in the R. Kelly content and all the time being poured into these motions. But without further ado, let's jump into the motion. All right, we stopped at Racketeering Act 2, which was sexual exploitation of a child. And this centered around him bringing an underage girl to video them having sex in his studio or something.
Right. Well, I think it's interesting to first point out the way that the government did it. They did it by the first names of the girls or the child. So when you go through, like you'll see this Racketeering Act 2, it's Stephanie, right? As we go through, they change the names of the individual, although the charges are very similar. And that's why there's really no need to go through each one of them, but to just explain a certain type. And this is the sexual exploitation of a child. If you remember earlier, they argued about the fact that the enterprise couldn't be his art form or his music or his entourage that produced the music. Mm-hmm. Yet, if you look in this one specifically, and the other ones as well, in this one, the sex act took place in his studio. Well, this is his music studio. It's certainly part of the enterprise that they were alleging earlier, and that the defense was arguing, oh, it can't be an enterprise. If you look at the other counts, they not only talk about studios, but almost all of the girls were met at concerts. Almost all of the girls were given his phone number, not by him, by some underling that must work for him. So they're passing out his phone number for them to contact him later on.
And also the traveling across state lines was for concerts and stuff like that.
They're always to go to concerts or sometimes enticing the girls thinking that they're somehow going to have a part in the concert. Yeah. Now this one talking about Stephanie. And again, it goes through, it's a kind of a common theme by the lawyer presenting this motion. They argue that there's no way a jury could find this beyond a reasonable doubt. And again, I think that's a misnomer to use that, because the real burden here is looking at it in the way the prosecution presented it. Could it be beyond a reasonable doubt? Not looking at both sides of the argument. They look at it as, you look at our side and you look at their side, oh, there's plenty of reasonable doubt. But again, that's not the standard. In this case, also interestingly, they did not have the video. So they just had testimony in this case to prove it.
But you don't have to have the video for cases like this. The testimony is evidence.
And the other thing they argue in this, as they argue in others, is the consensual nature of the sex. Stephanie, and I don't know if it's just her, but a lot of these girls had long-lasting relationships. This wasn't an isolated one-time thing, but they would have sex with him over a period of time.
And she responded okay when he said that he was going to pick her up to video this. And she was consensual, definitely, even though she regretted it later, the lawyer says through here.
Right. And some of the words they use, she said she was humiliated, right, and those kind of words. And the defense is arguing, it can't be that way because she was not forced or coerced or persuaded.
Right.
Well, I think that the law is going to be clear when it's responded to. When you have a juvenile, the laws are designed to protect juveniles. So when an adult is having sex with a juvenile, even if it's consensual, there is almost a presumption of some adult persuasion. That's why the law is written like it's written.
It's pretty much strict liability.
Yeah. So they're not really going to get away with.
What
saying
about the VHS tape argument?
I don't even really understand what they're talking about.
Saying that it's insufficient to prove that it's this device. I don't think that's going to go very far.
I mean, at least hopefully the judge is old enough to remember VHS and he'll know it's a device.
What about Racketeering Act 5, the Mann Act violations, Geronda, and all of the Mann Act violations that are in here, you can pretty much summarize, right?
Right. Well, there are some differences. And I can summarize those because
Okay.
in this one in particular, he calls on a cell phone. Again, interstate commerce, which we talked about before. They used a cell phone, which is a device used in interstate commerce. And they used that cell phone. And in this one, interestingly enough, she lied about her age, apparently, and told him she was older. And again, that doesn't matter. Although they think it really matters, the law, it says you can, if you're 12 years old and you tell somebody you're 18 and they have sex with you, his defense can't be, oh gosh, I thought she was 18 because she said she was 18. That's not going to work. Although that's where in fact, that's the major part of the argument in this racketeering count, was that anybody looking at her would think that she's older than 16. But again, I don't think that's going to wash. The next one, which is Act 6, is a really interesting concept. This is the act of, this is forced labor.
Yeah. Same one, Geronda.
Right. Oh, this is a really interesting, I mean, prosecutors in this case were inventive. There's no doubt about it. I think racketeering was an inventive use of the prosecutorial function. And I think forced labor is inventive. What was the forced labor? Oral sex. And he argues, she argues in here, just like previously when they talked about, well, was racketeering really designed for this kind of thing? And she's right, it really wasn't. Was forced labor designed for oral sex with a minor? I don't think that Congress was thinking about that when they passed the forced labor. They were talking about bringing in people from another country,
sweatshops and stuff like
those
that.
kind of things. Well, again, how is the statute written? It is written that any type of forced work can be a crime. And then they argue, well, it can't be forced. Well, yeah, maybe he was angry at her and he pushed her around a little bit, but you can't show that that anger had anything to do with the oral sex. But again, the statute's written that way. I think you can use it. I think the prosecutors were really in their right in saying that that oral sex was a forced labor situation in this, under these facts. So it was okay. Going to Act 7, another sexual exploitation of a child. Again, they're saying it was continuing and it was consensual. Those are the arguments. Arguments I don't think are going to fly. Act 8 starts another really interesting argument. Act 8 is a Mann Act, willfully transporting a female for an illegal act. What was the illegal act in 8? Interestingly enough, it's infecting somebody with herpes.
Because she was of age.
Right.
Jane was of age. So it's not the child sex transportation. It's for him to give them AIDS, which is battery.
Yeah. So, and there was a crime in California at the time that if you willfully expose someone to herpes, it is a crime. You can be arrested for it. Interestingly enough, when this case goes to trial in New York and they use that as a prior offense, that statute had already been repealed in California. So they use a California statute that was repealed as the reason for a Mann Act violation when they charged him in New York, because it was an active statute at the time that he gave herpes to Jane. So that, again, very, inventive, not something I'm sure anybody thought of when they wrote the statute, but the prosecutors thought of it.
And again, they had some nitpicks with some of the testimony. She doesn't remember when she went to California, what time it was, things like that.
Right. Racketeering 8 is interesting. And that one I found interesting because the defense in that case is blaming the mother, saying the mother enticed Kelly. That's an interesting.
Well, that was a kind of a
argument.
common theme for these parents to kind of like sell their children.
Right, because they were looking for stardom. Again, was the enterprise his branding? Of course it was. Because think about this. Would that mother have pushed her daughter onto him if it wasn't for the fact that they were looking at stardom based on the fact they were going to be associated with Kelly? So again, the enterprise comes into it and it shows it is independent and operates independent of the individual.
I think all this explanation, though, and all of this creative prosecutorial conduct or whatever is not how it's supposed to be. Like, I mean, I think this is pretty clear that they are trying to fit this square peg into a round hole. and it is all the bad acts, and they wanted to get him for something, so they had to find something, and they found RICO and tried to use it.
Right. And it's
And
a
that's what this
shotgun.
lawyer is trying to prove here with all of the
Right.
with this motion.
And it's kind of a shotgun approach. They threw as much as they could into this, all these racketeering acts. And although they charged the racketeering acts, it's interesting to note they didn't charge those as independent crimes. They apparently just did Jane, for some reason, on counts 2 through 9, I believe, as independent crimes. People, again, understand what we're talking about as racketeering acts. These are things that have to be proved in order to prove the crime of racketeering. A jury has to unanimously find at least 2 of these in order for it to be a conviction for racketeering. These are not independent crimes in themselves, and Kelly was not sentenced based on the racketeering acts. He was sentenced on racketeering as a whole and individual crimes that come after the racketeering acts, which are counts 2 through 9, which are Mann Act violations involving Jane. So that was a separate charge in the way they charged.
What about the intent? Did you find anything with, because they talked about intent, kind of how there was no link with his intent to expose herpes, with that's why he traveled across state lines. So like usually the Mann Act is you're taking someone from Georgia to New York to sell them in New York, and human trafficking. But this, he was just traveling where he needed to go, and the travel was just secondary to any of these crimes.
Well, that's interesting because the jury instruction on that does say you can have multiple reasons for transporting somebody across state lines, but that it has to be a significant reason. In other words, this infecting somebody with herpes has to be a significant reason.
I don't think they can prove that.
That one's right, and that's kind of tough. Although, if they can say, and I think my guess is this was their argument, he sure intended to have sex with these girls. That's why he brought them, and he knew if he had sex, he'd be infecting them with herpes. So that probably
I guess
is their
you could
argument.
say that that's his motivation for bringing them along, but I don't know. I think I really do. I mean, listen, it seems like they've got a lot of negative facts here for R. Kelly and a lot of bad evidence to sling at him, but I do feel like this is not a great precedent to set, that they're going to use this type of statute to get somebody who has sex with a bunch of girls in different states, because that can spread, I think, to people that maybe don't live the same kind of lifestyle as R. Kelly. I don't know. I don't think they're going to win this motion. I assume you don't either.
Well, I don't. And let me tell you another thing too, is from past videos, if your listeners looked at them, we explained judicial philosophy. And in this case, these statutes are eventually, my guess is this Kelly case will eventually go to the Supreme Court. It's the kind of case, because it is so unique and different and high profile, the Supreme Court may eventually hear it. And then you're going to see the division between conservative and liberal justices. Your liberal justices look at the facts of a case as the primary motivator, and they'll say, gosh, these facts just don't fit into what the intent of the statute was. The conservatives will say it doesn't matter what the intent was of Congress. What matters is the words in the statute. And if this crime fits the words, then we don't look at whether or not it's unusual or inventive.
Yeah, and that's why I think, like, as a lay person, if I'm on a jury and I get explained to this by the prosecutor, that's why I thought he was going to get convicted, because I don't think they could see past all of the bad facts. And literally, if the prosecutor's explaining these to you, it does fit the words. Just knowing as a lawyer what this is supposed to be used for and kind of what the spirit of the rule is, I do have an issue with them charging this and going forward on this and convicting him of this and him getting sentenced of this.
Right. Well, the spirit, that's the thing. Do you look at the spirit of the statute, the spirit of why it was passed, or do you look at just the cold words?
Yeah. Yeah. This is a tough one, I think, because it's not really, he's not really a sympathetic criminal defendant, but I do think it's kind of a rough job that got him. But again, going beyond this case, there have been some bizarre uses of the racketeering statute. And one in particular that I've always found bizarre is the abortion clinics. Anti-abortion picketers, pro-life picketers that are walking around have been charged with racketeering because they were able to find it was an organization that grouped them together to do the picketing, and they were preventing people from crossing or from getting into where they want to go. They were blocking the street. They were committing these crimes.
and they charged them with racketeering. And the Supreme Court has upheld using racketeering for other purposes other than the traditional purposes we're talking about, like the abortion clinic.
Some other things that have been allowed for racketeering charges to go against them, some of them were civil, but Donald Trump, which is pretty good crossover to R. Kelly. Major League Baseball has had racketeering charges leveled against them. Greenpeace, environmental organization, the Catholic Church, which again has some similarities to R. Kelly, this R. Kelly case. Right. I mean, because that's what it was about as well. The Los Angeles Police Department, very interesting. Pro-life activists, like you already talked about. So I mean, those again are all not common ways you would think that this would be applied, that it was allowed to go forward on, which is why I do think this is going to allow, he's not going to win the judgment of acquittal. No. But his better chance might be in the appellate courts if an appellate judge sees it differently than this judge does. But this has all happened pre-trial already. All of these arguments have already probably been made, and the judge has already ruled against them, so it shouldn't be a surprise. I think R. Kelly's best chance at winning any of these pre-trial or post-trial motions, post-conviction motions, is his motion for new trial based on ineffective assistance of counsel during voir dire and not picking a fair jury. I think that's his really only chance to win, and that would be for a new trial, not an acquittal.
I think you're probably right.
I don't think he's going to win. I'm saying that's his best chance.
It's his best chance. Right. I'm glad you said that, because it's extremely difficult to say you hire a lawyer, you pay a lawyer. Now you're not happy with the lawyer. You chose. He's not wasn't a public defender you were forced to take.
Right. They made strategic decisions and you lost. You can't go back and now second guess all of the strategic decisions and get another shot at it, a second bite at the apple, as they say.
Another thing you said that I think that everybody should know is when you talk about civil racketeering, we've talked about this being a criminal case. These exact same things, you can sue somebody civilly and you can allege racketeering in the civil suit with the same elements that are in the criminal case to collect money damages.
Right. And that's why how they're applied, it wasn't necessarily set out or thought by the spirit of the rule that it would apply to even those people that I read, just kind of like R. Kelly. So let me know your thoughts, as I'm sure you will, in the comments. This was a much more brief overview of the second part of this motion for judgment of acquittal that R. Kelly's new lawyer has filed. So we'll keep watching this case. Hit the like button if you're interested in this content and subscribe to our page if you haven't already. That's all we got. Thanks a lot.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com.